Hi, Nick Dogan, North State Law. We safeguard your professional license so you can get back to business. So we got a case law update today, and this is an important one for North Carolina administrative law. The case is Savage versus North Carolina Department of Transportation, and it is a North Carolina Supreme Court ruling. So this has to do with a judicial deference of agencies' interpretations of ambiguous statutes. The important other case on this is Loper Bright Enterprises versus Raymundo, and that is a U.S. Supreme Court case that overturned the Chevron doctrine that came out last year. Very important case in this particular area of law. Check out a video that I did on that last year. I did that video roughly in July or August of 2024, right after the Loper Bright Enterprises case came out. And that case overturned the Chevron doctrine, which basically told judges to defer any ambiguous interpretations of the statute to how the state agency, or in that case, the federal agency, has interpreted it, which flies in the face of any sort of common sense because judges are tasked with interpreting, easy for me to say, laws. So fast forward to this year, we get this Savage versus North Carolina Department of Transportation case up to the North Carolina Supreme Court. And I want to read a couple lines real quick because this is a very well-written opinion. I encourage you to check it out. The case is going to be in the description, or a link to the case is going to be in the description. And also there is a news article link as well in there. Check out the case yourself, and if you need kind of some sort of interpretation of it other than this video, then check out the link to that news article as well. But jumping right in, so this is basically on the bottom of page 1 into page 2 of Justice Dietz's opinion. And it says, several decades ago, parroting federal law, the Court of Appeals held it, quote, a tenet of statutory construction that a reviewing court should defer to the agency's interpretation of a statute it administers so long as the agency's interpretation is reasonable and based on a permissible construction of the statute. And that's a County of Durham versus North Carolina Department of Environmental and Natural Resources from a 1998 Court of Appeals case in North Carolina. And then he goes on to say, we never approved this interpretive rule, and it directly conflicts with our own precedent requiring courts to review questions of law de novo. De novo is Latin for anew. And he goes on to talk about, in his opinion, that we traced a lot of these North Carolina Court of Appeals case that says essentially the same or similar things to the County of Durham case, says that, judges are to defer to agencies' decisions, essentially when there is ambiguity in the statute or unclarity in the statute. And this all goes back to the Chevron case, which is a U.S. Supreme Court case back in the 80s. And hey, the North Carolina Supreme Court's never had a say in this. We never told the North Carolina Court of Appeals to start deferring or start having judges deferring to agencies' interpretations of the statutes. We know where they got this, so we're making a ruling on this 100%. And not only are we saying that, no, you're not supposed to, judges are not supposed to defer to state agencies when there's an ambiguous statute, but the underlying case that led off to all these North Carolina Court of Appeals cases to basically say that we should do this, that case has now been overturned. So we are definitively saying, that's not proper anymore, and we're not going to do that. The importance of this in the administrative area of law is when you have an appeal from a state agency, and licensing boards are defined as agencies under 150B, which is the Administrative Procedures Act. So those boards and agencies, when you have a hearing and let's say it doesn't go your way, a lot of things happen, and sometimes people make mistakes and they make the wrong decision. And let's say that happens. You have the right to appeal and have your case heard de novo, which is anew. And there's some kind of things in there that don't make it as anew, but for lack of better for argument's sake, it's supposed to go and be heard anew in Superior Court. So the way that it's been done a lot is a lot of these Superior Court judges, they'll go, oh, well, they'll have it in their mind that I have to defer to the state agency's interpretation of these codes and statutes. And some of them will even, you'll look at the decision and like, well, you're not, it's not even an ambiguous statute and you're still deferring. So, the crux of a lot of the problems that we were having was if it's an agency interpretation of an ambiguous statute. So now even the interpretation of the ambiguous statute, they're not supposed to just defer. I mean, they can take into consideration how an agency or board is interpreting their statute, but they don't have to defer to that. They can come in and make their own decision and hear the case de novo anew like they were supposed to. So huge case, glad it finally got done, creates state precedent, and that is now mirroring federal precedent in this particular issue. So got that taken care of. That's fantastic. Kudos to the attorneys that did the appeals and got it all the way up there. Great job. If you got any questions on anything, please give my office a call or text, 919-521-8810. But before you do that, check out the blogs and videos. I got a lot of blogs on my website, northstatelawfirm.com. I got a lot of videos on North State Law's YouTube channel, so check those out as well. And I hope everybody has a fantastic day, and I hope this wasn't enlightening for everybody. So everybody, hey, thank you. Bye-bye.